মিউট করবে, আনমিউট করবে।
এখন তো অরিজিনাল হবে আর জাজমেন্টটা গেল কোথাও? আরে
File one appeal without the certified copy, my lord.
Order passed.
Or on 1st August. 1st August.
My lord, excuse me to.
My lord, I have a similar, my lord.
Number 171. Order passed on.
My lord, 17th of July, my lord.
My lord,
Certified copy had not been
applied.
application.
Upgrade, my lord, as because the second round counseling process already started from 9th August. Completed will be on 14th August at 2 p.m. In the meantime, if this matter is not heard, this matter will infrastructure. And all allotted seats will be allotted to other candidates. Which matter? PWD candidates, my lord, benchmark. Which matter? Item number 171. Are you mentioning upon notice? I already I informed them. Are you mentioning upon notice for upgradation? No, my lord. Then you mention upon notice. My lord, if I notice today, I mentioned. Your lordship say, mention upon notice. Your lordship fixed tomorrow. Yes, I mentioned that matter. Upon notice, yes. Call the list.
My lord, Mr. Ganguly learned AGP is appearing in this matter, my lord, for the appellants. My lord, he's in some difficulty. My lord, may the matter come up next week. Somnath Ganguly, Mr. Somnath Ganguly.
Take down.
And one more thing, my lord, I should be candid. On the last occasion, 27th of July, my lord had directed us to effect service on the private respondents. My lord, that also could not be complete. I'll come back with that as well.
On the prayer of the Land Council for the state, the matter stands adjourned for one time. The time to serve the copy of this application upon the writ petitioner is extended till Monday. An affidavit of service shall be filed on the agenda. Next.
Great reminder.
Next.
Madam, for this state, my lord, which is the appellant, my lord. This is the issue has already been settled by your lordships in another division bench, Adiluzzaman. So, my lord, before entering into service, he enrolled. Thereafter, he enhanced his qualification. So I have nothing to say, my lord, as the issue has already been decided.
Order of the learned civil 74. Order of the learned civil judge, page 74.
Very well.
Relying the Adiluzzaman.
No, single judge has not relied upon Adiluzzaman.
No, relied his lordship's order. Your Adiluzzaman has been relied.
No. Single with Animesh
Animesh Chaudhary's matter. Animesh Chaudhary's matter, my lord, relying Adiluzzaman, repetition was allowed.
The council.
Handed over.
The issues raised.
এক নম্বরটা একজন হয়েছে আমি গেছি এক নম্বরটা কবে হলো একজন 15 মিনিট ওই সোমনাথের গ্রাম পাইনি আলো করছি সোমনাথের
Yes, for the list. Yes, for the list. Photo. ঠিক আছে তারপর ডিভিশন বেঞ্চটা বসবে Yes, for the list.
এইটা
Oh, yes.
অ্যাপিলেন্ট একটু চেঞ্জ হবে
Yes, for the list.
Happy for the applicant, my lord.
I'm happy for the rest.
কি হয়েছে এটা কি কারেকশন হোয়াট কারেকশন
কারেকশন করে পাঠিয়ে
ডেমিনেশন next
Item number 2, for the appellant, the correction, only one word. Their lordship was directed to kept vacancy for 2 posts. Well, it will be 1 post because the respondent's petitioner is 1. Instead of 2, it will be 1, my lord.
কি বলছো কি
For the 1, 2,
are you
4th line, first paragraph, 4th line, my lord.
are you mentioning upon notice
My lord, Mr. Jana is,
you are for the state
no, I am for the appellant. Mr. Jana is the petitioner.
and who is for the state where is Ms. Shamanto
Mr. Samanta is not.
have you given notice to her
My lord, Mr. Samanta lordship was because of lordship was directed to file a paper book and my lord, that to be served to the my lord Mr. Samanto. My lord, paper book could not my lord prepare because of it, there is my lord, some correction, my lord. Only this portion. But I could not prepare the paper book, my lord.
take down
The learned single judge will be directed to give counseling against 2 posts.
Well, that was the,
no, but because there is one now
yes, petitioner
I
is the
have no
one.
objection, but the learned single judge directed to conduct counseling against 2 posts.
No, because of my lord, the petitioner, my lord, the writ petitioner is my lord, serial number 50. There is a 49. 49 has not come before your lordships. That's why my lord, the learned single judge has directed to counseling for the 2 posts. But the here my lord, lordship has injuncted for kept vacancy or 2 posts, but it should be 1 post because if ultimately the petitioner, my lord, I lost this appeal, then the petitioner will succeed. Then my lord, he get my lord, 1 leave.
49 has not responded
No, no. Neither she has come nor he has a respondent.
just come at instant
My lord, Lordship was directed to file an informal paper within 2 weeks. My lord, the 10 days has already been lapsed. My lord, only 7 days to be extended.
Time to file paper books.
Huh.
They extended by 2 weeks from date,
Lordship was extended for 1.
by 2
Well.
weeks. Yes. Yes, for the rest.
Item number 3 and 4, Lordship, I appear for the appellant.
Lordship, I am for the
It's come
plaintiff
up as my
respondent.
instance, my lord. Lordship, there are 2 appeals, my lord, one against an order of injunction, ad interim order of injunction, another against an ad interim order of attachment. Lordship, the facts are, Lordship,
But Lordship, they have filed subsequently 2 appeals. Those are not appearing.
those are, Lordship,
But why
from
it
the
is, why it
extension.
has, why it has come before us?
Lordship, your Lordship would recall, yesterday I mentioned this because for every extension, Lordship, I have to file another appeal. On 1st August was the last date,
Now, what is the, what
and
is
this
the,
was
what is
supposed to
the,
appear before Justice.
Lordship, tomorrow is the next date, Lordship.
Tomorrow
In the
is the-
court below.
carry that tomorrow let it be decided.
Lordship, yes, yes.
Have a section 8.
They
Lordship,
have filed the section 8.
Our section
Hearing
8,
of section 8 is going on, Lordship. This is the written communication I received from my counterpart in the court below.
But thing is,
Hearing is going on.
if a section 8 is there, unless the section 8 is decided,
Yes, the hearing is
order
going on.
cannot continue. And if there is a prima facie arbitration clause, then there's
which
a clear
they had invoked.
section
But
5
Lordship, the problem is if Lordship, it is going on, Lordship, it was heard.
may be
Let
going
it
on.
be heard out tomorrow, Lordship. Let the hearing be concluded.
Not the question like that. You are thermal chalk construction.
Lordship.
Now, you have, what is the suit for?
Lordship, money suit, Lordship.
Money suit,
Yes.
Damages.
damages. So how your suit is maintainable once there is an arbitration clause? And if the court has seen that clause, how the court can possibly?
No, Lordship, I have it is not a case that Lordship, I have suppressed about the everything.
Not a question, by reason of section 5 of the Arbitration Conciliation Act,
Lordship,
the court has.
my specific pleading is that Lordship, thereafter, they have waived that arbitration clause. That is my case, Lordship.
You agree to, we refer it to arbitration.
Lordship, the hearing is going on, Lordship. Tomorrow is the next day.
Therefore, what is the interim order there?
Lordship, attachment of the property, Lordship, and not to sell the property.
Suit for damages.
Yes,
A
Lordship.
Suit for damages unless it is determined.
But Lordship, they are Lordship trying to Lordship dispose of that suit property, Lordship. We have spent Lordship crores on that property. Thereafter, Lordship, they have cancelled that agreement.
They have not spent crores. The suit is entirely for damages, which is their loss of profit. They have averred
But whatever is
that
there.
they have made certain
whatever is there,
payments.
it has to go to arbitration.
True, Lordship. But Lordship, hearing is going on. Tomorrow is the next date, Lordship. I am enjoying Lordship from October 2022. They have never taken any steps, Lordship.
When they
Prefer
file
to
section
appeal.
8,
Lordship.
when they file section 8.
Section 8 subsequently.
The first date.
Date ta karo, what?
On the first date, when the returnable date, we filed the
Yes.
section.
Without considering this, how the court can automatically extend the interim.
Lordship,
order,
hearing was going on.
the court has to see whether the arbitration agreement is there or not.
True,
At that
Lordship.
stage, so you can, we can appoint an arbitrator.
But Lordship,
and-
hearing is
and
going on.
whatever- No, no, and whatever interim order you are enjoying, that may be for 4 weeks, with liberty to the arbitrator to decide whether. On a
That
fresh
can be done, Lordship. That we
on
don't
a
have.
fresh application,
Lordship.
on a fresh application.
But on the personnel, my lord, we have to agree, my lord, and I have
So
to take
we'll appoint,
instruction.
both of you constantly appoint, there's no problem.
Lordship, that I have to take instruction, yes.
Lordship keeps it tomorrow, my lord. I shall also take instructions on all this.
No, but you have a matter fixed tomorrow there,
Yes.
so.
Let them, Lordship,
Or
we
my
will
lord,
inform
we
before
can come
the,
at 2 p.m. my
no, no, we will inform before the landed trial, Judge.
lord.
That we can do. Because Lordship, we have also admitted to the agreement, Lordship. We have mentioned about that agreement that
So
we have
you are-
also
so
admitted.
You are agreeable to an arbitrator being appointed?
Yes, because I preferred section 9 previously, Lordship.
Then you
Section
abandon
9, that is
Yes.
why the arbitration was invoked.
No, that
to file a section 9 previously, how your suit is maintainable.
no, thereafter, Lordship, we sat, Lordship, there was discussion. Thereafter, Lordship, It's our case that they waived that arbitration clause, Lordship. Thereafter, I filed this suit.
Section 5 says how, when the waiver takes place.
True, but Lordship, the averment, I am speaking what if the averments are there. Thereafter, Lordship, they have filed this. They have entered appearance in the suit and filed.
Appoint an arbitrator here and now.
True, Lordship, that can be done.
Appoint an arbitrator here and now.
Or Lordship, we can agree to an arbitrator and we can inform it in the court below tomorrow also. That also we can do.
No, Lordship, my request will be, my lord, keeps it at 2 p.m. My lord, let my client be also present, my lord.
No, their client may not be present. We don't know.
That is why, Lordship, tomorrow before the court
The-
below, Lordship records it that we will let
Before
the
before
arbitrator
the
be
court
fixed.
below, Lordship, we
Please
would,
listen to the order.
Lordship,
Please listen to the order. So we can dispose of the appeal and the application.
but not before the court below, my lord. Lordship, we can agree to an arbitrator here. It is better.
Lordship, here and
for
now,
us.
Lordship, it is difficult to get instruction, Lordship. Tomorrow is the date. We will, Lordships will record that both of us are consenting to Lordship appointment of arbitrator. The name will be fixed there, Lordship. We will take instruction in the meantime and Lordship, tomorrow, Lordship, that
If it
will be
is-
fixed.
It is only on agreement, my lord, that the arbitrator can be, we can do it here, Lordship. But before the court
can
below, I
appoint,
do
there's no
not have
problem.
any
We
confidence,
appoint it here and now.
Lordship. That
Yes.
would be better.
We appoint here and now. Straight down. The plaintiff filed a suit for damages based on an agreement which contains an arbitration. Section 5 of the Arbitration Conciliation Act 1996 is satisfied. In view of the existence of the arbitration, in view of the
Camera
existence of the arbitration clause,
respond number 1.
suit is not maintainable. However, in the given facts and circumstances of the case, no, full stop. Previously, the plaintiff had filed an application under Section 9 of the Arbitration Conciliation Act. The plaintiff has accepted the court has jurisdiction to convert the application filed since
October 2022, Lordship.
October
28th October 2022. 28th.
October 2022.
And we were in court, my lord, immediately in
Very well,
December.
20 October. The interim order shall continue for a period of 4 weeks from date. The parties have consented to the appointment of an arbitrator to be appointed by this court. Full stop. Now, the learned counsel for the parties have submitted that the parties have no objection in the event an arbitrator is appointed by full stop.
Order of the court, because Lordship, my client is not present.
No,
Or order of the court.
you have to give a
Yes,
consent,
yes.
otherwise we cannot.
True. Lordship.
We agree to, there's an arbitration clause.
Lordship.
Other perilous processes, we have to dismiss your suit.
Lordship.
Bola? According,
This is development agreement. We have terminated and they
we have
say,
terminated.
Lordship, we are the owners, my lord. They are the developers. They ask for specific performance. They ask for damages on the basis of termination.
Accordingly by
So, my lord,
consent of
once they ask for damages, they have
We are
given away
recording your
their right.
consent. We are recording your consent. Both of you are consenting with Rishi. By consent of the parties, we appoint Mr. Ranjit Kumar Bagh, Justice Ranjit Kumar Bagh, a former judge of this court, since retired, as an arbitrator. Full stop. As an arbitrator. The
আমি জানি না আমাকে তো আকাশ থেকে ফটো
কমেছে তো একটু নিয়ে এসো, ওটা চার্জে লাগিয়েছি।
Yes? Anyone is appearing?
No, nothing, no one from our side.
Correct, ওখানে
No,
কি
no,
আছে?
no one from
Huh?
outside. আমার তো আর কেউ নেই।
এখানে correct দিয়ে দিয়েছে ওখানে। Are you appearing in this matter?
কে?
কি? বুঝতেই পারছি না।
The screen is off, even we can't see.
Huh?
Screen is off, we can't see.
IT লোকটাকে ডাকো। আরে কাকে একটা দিয়েছো এখানে? না, এই ম্যাটারের জন্য? না তাহলে অফ করে দাও।
Live streaming
কি বললো? হুম? As an arbitrator, the given, you have not given the number.
I've number to দিয়ে গেছি. I'm told that the number was
No, give
supplied.
the numbers.
Anyway, the
Supplementary cause
the numbers are
এই চারটে matter.
FMAT
37 and FMAT 38. My
না,
junior.
এই দুটো আছে আর ওই দুটো। হ্যাঁ। হ্যাঁ। ওই না ওই দুটো ম্যাটার নাম্বারটা দাও।
FMAT 37 of
প্লিজ
20
গিভ দ্যাট প্লিজ।
এটা তো ওরা সার্ভিস করে ফেলবে। ওই যে দিচ্ছ।
ওখানে করে দাও। The learned counsel for the appellant submits that
ওরাটা জানিয়ে দে।
there are two connected
December 2022.
And they never took any steps, Lordship.
Humorous
The suit is
mention.
not maintainable. Yes,
I appear for the appellant, my lord.
I was a respondent.
what is
In
matter?
this matter, my lord has referred for mediation, my lord. Joint mediator, ultimately the mediation has been successful, my lord. I have mentioned with,
So it has come before us, why?
since my lord is having present determination, my lord.
Oh, I see.
So that I mentioned this matter before your lordship. Initially, we were also not hopeful, but subsequently the mediator and pursuant to my lord's order that the children should be present.
Then you need to file an application before the London District Judge for mutual divorce.
In that event, I kindly waive that
Yes, take down. Left.
One, the courier has come back as left without, no, the speed post has come back as left without instructions. Addressee left without instructions. I had a copy. No? Look, the
Date of.
look, there was an alternate address where we had written letters to. That also they've not replied, but we can try and serve there once. Or we can just, your lordship will keep this order and send us back to the lower, to the court below, and then we can try and.
Postal
Sorry.
envelope returned to the addressee. The endorsement left.
Wait.
একটা কাজ করে দেবো, শোনো, একটা কাজ করে দেবো, একটা লাইন অ্যাড করে দেবো। In the event steps are not taken in terms of this order,
He joined, my lord,
yes,
from 15th
Lord,
July.
Leonard Senior is
I'm
standing.
not concerned with that, it's concerned someone's salary, madam.
My Lord,
Ask the
thank you.
chairman to be here at 2.
Okay, my Lord, I am informing my.
And why this headmaster, assistant headmaster is not there of the school? Have you communicated this order?
No, my lord, I have not communicated because my lord, lordship's order there, my lord, learned advocate for the state is directed to comply this order to the concerned school immediately.
Communicate, it should be not.
So, my lord, if you lordship direct, my lord, I will communicate, my lord. My lord, he
Take
got
out.
only, my lord, 1 month salary, my lord.
The state is not represented.
বলছে
29, note number 18.
What is the instruction, madam? She may be there. You should, when you are appearing, you must have the instruction. What the board is supposed to give us an instruction with regard to the request made by the headmaster.
My lord, kindly provide short passover so that she can instruct.
No, you should be there. We cannot go on adjourning this matter. Once you are here, you should be with the required instruction. बोलो। No, to the headmaster slash assistant headmaster slash teacher in charge of the school concerned. आगे कोड
No, my lord.
Why not? You are supposed to do it.
Sorry, my lord.
The Learning Council for the state submits. We will communicate immediately. That is our order.
I shall communicate.
Yes, next matter.
I'm for the state, my lord.
I appear appellant.
Of the. I am for the university.
My lord.
I
Led
am
by,
for,
led by Urmangsi Chakraborty, my lord.
Yes.
yes.
বলো ভার্চুয়ালি অ্যাপিয়ারিং করছে অ্যাপিয়ার করছে
Already বলে
আছে
Affidavit of service. না, দুটো আছে। আছে।
Yes, where is the affidavit of the university?
Well,
Because-
actually, we have already filed an affidavit before the trial court, and the
They have passed an order directing the university to file an affidavit clarifying the above aspect of the matter.
well, this can, in view of the latest judgment of the Honorable Supreme Court, that if a candidate participated in a interview, he cannot challenge the same one.
No, that is a,
Therefore-
we have directed you. the
Well,
uni- file an
because there is no time, actually, just I received it yesterday evening. So if needed, I can file an affidavit.
You file an
if-
affidavit, that is a direction.
Or
The
the, my next fix on next Friday or Thursday, I will file an affidavit.
Who is representing the university has filed a vokalatnama in this matter, in the appeal?
Yes, earlier.
No, who is your advocate on record?
Advocate Jeba received this advocate on record. He has not filed anything.
You are the advocate on record.
Yes.
The learned counsel for the university has paid for time to file an affidavit clarifying the position as indicated in the order 27 July 2023 within 1 week from date. Within 1 week from date,
Yes, well, 1 week. Because I,
the matter stands adjourned for 1 week. Now,
well,
1 week,
well, let it be fixed on Thursday, because I will not be here on Tuesday, or Thursday or Friday. Anything.
Thursday.
No,
So
Friday,
we are saying 1 week. 1 week, 1 week.
1 week by from today.
Yes, 1 week from date, upon prior service. The bhashan for the applicant. Your good name, madam?
Zeba Rashid. Zeba Rashid.
Seba
ZDBA Zeba Rashid.
appears, it also for the university, yeah. Seba Rashid.
Jeba Rashid, ZEBA.
Seba Rashid, an advocate on record for the university, undertakes to file vokalatnama on behalf of the university. By Monday,
By Thursday.
you have to file your vokalatnama by,
Yes,
ma'am.
yes.
Right.
এই অ্যাপিয়ার
Lordship and get.
138, my lord. I am for the
the order of
response. Till date, no copy of the appeal application, nothing has been served. না কিচ্ছু স্যার কি করছো না তোমরা না সত্যি কোথায় একে পাঠিয়েছে কাউকে না আরে এটা তো আমার অ্যাপ্লিকেশন প্রিয়াঙ্কা তোর
the improved order shall, the improved order, the order of stay.
টাইম চাইবে যদি ওরা দেয় না চট
Shall continue for a further period of 4 weeks or until further order which is reserved. Yes,
My lord, I am for the
Nothing
School
has been
Service
served.
Commission. I am the appellant.
you have not served.
It is a fault on our part. If it has not been served, I will check.
My lord, only
Definitely, I will serve
thing,
the
my lord,
copies.
That was passed in the month of September, appointment already given. In the month November, my lord, appeal has been filed, my lord, no copy served, my lord. I have joined commissioners acted with the order also.
My
Complied
lord,
with the-
oh, my lord, let me serve a copy upon my learned friend. We have come up against the question of law involved. We have complied as far as giving the appointment is concerned, but the interpretation of the rule is what is necessary.
There is no scope of any interim order, my lord.
No, I'm not asking for any interim order.
Be hard on paper.
I'm only asking that if it is taken up next Thursday, then I'll serve my learned friend in course of today. And I will also come back with the,
The appellant, the learned advocate for the appellant is directed to serve a copy of the Meona appeal and stay petition. Upon, who is the advocate on record upon?
My lord, upon Mr. Orko Nundi.
The learned advocate on record. For the respond number 1,
No, my lord, I am in the writ petition, my lord. I made an application for
the-
addition of party.
for the respondent number,
My lord, added respondent number, my lord.
What is the name
Respondent
of your
number
client?
7, my lord. Priyanka Noshka. Priyanka Shaw, number 7.
No, your name is not there.
My lord, I filed an application. The
Oh, yes,
department,
respond number 1. Respond number 1.
my lord, my is scan 2 of 2022.
Respond number 1. By tomorrow you serve,
yes, yes.
the matter stands adjourned for 1 week. But what about the other respondents? They are not recorded.
But I will check if it's service has, if we miss service, I will serve upon all. We mentioned upon notice.
Yes, yes.
It was mentioned upon the notice I have.
Received the notice of the mentioning, but
Yes,
no
if,
copy.
if my learned friend had intimated me,
Yes,
then I could have solved it.
I have also intimated that to your.
Respond number 2 to serve for the and the other non-appearing respondents within 1 week from date.
Very
Next.
I am for the petitioner appeal. Your lordship's order dated 20th July, directing the DI to take some steps regarding consideration of my application under Utsosi portal for transfer. Your lordship kindly sees the order itself. Now I have got some subsequent development to the effect that I have got some posts in my rural area. One, I'm handing over those. If those posts may be accommodated to me. 20th July. Order.
It cannot be done in this way, bhai.
তাহলে দেখো।
So now, my lord, so far this
Now-
is concerned, my lord. Lordship has asked me on the last occasion with regard to 2015 circular. Now thereafter, my lord, after 2015 that circular, my lord, what we find is, my lord, that most of the schools are became without any teacher because of the only reason the male female teacher sought for transfer on the ground of, my lord, medical emergency, and his parents and all are in trouble. Now considering that, my lord, a notification has been issued, my lord, wherein, my lord, we have mentioned that provided an application for general transfer shall not be entertained by the concerned school authority if pupil teacher ratio of the school
That
fails
is your-
deficient.
That is your February 2023.
23, not September 29.
29 September
It is not
2022.
applicable to my case.
September 29, 2022.
Now-
That is in consonation with 2015 circular, my lord. Lord, may I just hand over the-
In February,
When she applied for transfer,
it is not there.
No, my lord, I am not on that, my lord. Because of the reason, my lord, because of this applied for all. Why I will tell his lordship, my lord. Lordship will see in second page, my lord. Second page, my lord, lordship will find the whole consideration is, my lord, PTR. And in this regard, my lord, Learned Advocate General also appear in a matter which is before the Honorable Chief Justice, my lord, wherein Learned Advocate General submits, my lord, that Learned Advocate General has points out that the mutual transfer and transfer on administrative grounds are permissible under section 10A, 10B, 10C of the West Bengal Service Law. He has also submitted that in the state government schools, aided schools and sponsored schools are existing, and the issue of some new appointment in the school is under litigation. He has pointed out that new proviso sub rule 6, rule 5 that I have handed up to his lordship, Service General Transfer 2015 has been added, keeping in view the need of maintaining pupil teacher ratio, PTR. He has submitted that if the petitioner submits the proposal for framing the guidelines, the same will be duly considered. Hence, we permit the petitioner to submit his proposal. My lord, this is the order, my lord, wherein, my lord, Learned Advocate General has submitted, and wherein, my lord, find this reference of 2015 circular, which I have handed up to his lordship.
No, see, we are on a situation because he's
Hard.
hard transfer was not allowed because of the single teacher post.
Single.
Yes, my lord.
Now, at that point of time, the circulars are such which would give her a right of consideration under the relevant regulation.
Now, my lord, may I join issue here, my lord? So far, this 2015 is concerned, my lord. This new amendment has been done in consonance with that 2015, my lord. Only that part has been modified and that has been reflected in the order.
But cannot be retrospective? It cannot.
No, my lord, it is now, my lord, the consistent view now, my lord, is with regard to, my lord, the PTR.
Yes.
The PTR. Now, in this instant case, my lord, if his lordship seen the PTR, my lord.
What we have done in a similar case, I think day before yesterday.
Yes, I have got this order.
Which order?
Your lordship passed on 3rd of August. All these issues, first transfer on distance gown, direction for
What is that order?
Yes, I have got
Directed
this.
to be considered by the
Considered.
commissioner.
Yes.
But
If you appear.
yes,
Yes,
yeah.
if that
My lord,
order-
instead of commissioner,
yes,
what I submit is, my lord, all the my lord, circulars and all, my
What
lord,
we have done is this,
lordship.
Mr. Boshamoli, what we have done is this. In terms of the earlier circular where we have allowed,
Lordship.
we have said that she will not be immediately released, but the
Lordship.
commissioner was directed to initiate a recruitment process
Lordship.
for filling up the vacancy, resultant vacancy because
Madam.
of her transfer.
Madam.
And we have direct, because there are vacancies, has to be a vacancy.
Lordship.
So that to be filled up within certain time.
Lordship.
And then she may be released. That is the
Instead of,
order we
I
have
think, my lord, I think it would be better instead of commissioner, my lord, let it be sent to the principal secretary. Because all this, my lord, has the author of this notification, guidelines and circulars made by the principal secretary,
No,
not
we
the
said-
commissioner.
No, we said
Lordship.
আচ্ছা আরেকটা order আছে
it was on medical reasons.
Lordship.
Yes. Similar order we have passed.
First was distance gown and second was on medical gown in that particular order of 3rd August.
তোরটা কি আছে ডিস্টেন্স
আমার distance, ailing parents, child.
That is the reason, my lord, this 2022 circular
that
has come.
order was passed, my lord, with an exception, my lord, understanding there is a medical problem. My lord, if your lordship, my lord, in a strictly go by the, my lord, retrospective prospective point, my lord, it is true, my lord, the earlier recruitment rule is there. But now, my lord, we are not in a position in the schools.
Says that the commissioner shall consider this application in terms of 6(4)(d) of the said rules.
Yes.
That your lordship kindly also open the PTR. My lord, that point also kindly, my lord, keep open. Why, my lord, I'm telling you.
No.
My lord, this is a view of the single benches thereafter. After passing so many orders,
My lord,
now
subject
the
to
single
correction.
benches are, my lord, having
my lord,
those staff patterns that there are only 3 teachers and 150 students, no classes of students.
See, if he is entitled.
That is why this public interest litigation was moved.
If she is entitled to a medical leave. and
Yes.
Transfer on medical ground,
Yes.
you have to allow this.
But it is not on the medical ground.
What
In
ground?
this case,
No, distance gown.
distance ground.
Distance gown. Bound. So not
No, everybody,
distance gown.
everybody is enjoying, my lord, house rent allowance.
No, single.
But they are not want to go. Then who will go to the village? My lord, you're
Teacher
putting a
gown.
question myself.
My lord, that is the reason, my lord, now the
This is
government
the
has
only
come up with
problem.
the
We are not against
nationalization
transfer.
policy. And that has been framed in terms of this court's order. My lord.
It's not applicable to my
True,
case.
but when she applied it,
My lord.
Since he
that
came,
were considered at that point of time, then
Yes.
he was eligible.
grateful.
Now, my lord, now the question is, my lord, now this 2022 document, my lord, kindly may I read, my lord, 29 September, in exercise of the power conferred under section 17, read with 1 to 10B of the Commission Act, my lord, the governor is pleased to hereby make the following amendments in the West Bengal School Service General Transfer
This
2015
amendment
published
will be
under
future,
this.
it cannot have a retrospective effect.
And that
No,
has
my
been
lord,
held by.
but my lord, so far this,
No, absolutely fine, but it cannot have any retrospective effect.
but my lord, since my lord, I have handed up that order also, my lord, wherein Landed Advocate General also, my lord, pointed out that now, my lord, this 5-6 has been modified to some extent with regard to the PTR. Now,
Why
what has
this?
fallen from his lordship, instead of commissioner, since, my lord, all this notification and all has been done by the principal secretary, so let it be tested before the principal secretary. Let him.
What tested?
No, my lord, so far this view of his lordship, my lord,
Merit of the.
let this be referred to instead of commissioner. Let it be before the principal
We
secretary.
have not referred to Commissioner.
My lord,
we have
kindly
only-
come
We have
to,
said that the
Lordship.
Commissioner will decide it in accordance with the rule that was existing prior when he initially make an application for transfer.
yes, only single teacher
Relevant
count.
rules that was applicable because his application has to be considered on the basis of the
Date of application.
date of application.
My lord, but now, my lord, the second question comes is with regard to PTR.
PTR
Here,
is not-
my lord, here,
there's
my lord, the court holds, my lord, that
not
total,
hold, it's a prima facie.
it's a, no, prima facie.
Yes.
No,
It has been,
No, but
mentioned.
no, but at the same time, there are overriding public interest.
Public interest.
Overriding public
My lord,
interest.
kindly
But may I
come to
just-
unamended
No,
rule.
no, may I just read, my lord?
Unamended
that-
rule, there
my
was
lord, may I
no
just read?
PTR was there.
No, but
Unamended rule.
this has been
5C.
subsequently been amended
If
because
the
of this
government-
reason.
If the government faces a problem, there has to be an amendment.
From the date of amendment, if it not retrospective
Because the
effect.
teachers have no indefeasible right to continue because when they take the job, they know that they have to join somewhere place.
Lordship,
Yes.
I'm grateful, ma'am.
So this is, the job is transferable.
Subsequently,
Just listen to us, transferable.
yes.
And then, yes, in certain areas, certain cases are there where your case may be considered, provided you fulfill certain criteria.
Yes.
Now,
I have fulfilled.
that's why I'm saying,
Hmm.
but suppose it happens that there are overriding public interest, what would happen?
My lord, already, but
Overriding
they are
public
to,
interest
they
is
are to,
subservient to the rules.
no, they are to fill up those posts by subsequent, my lord,
That is why
recruitment.
we pass an order in which matter we cannot recollect. We pass an order, we said that he or she may be retained to the post for a period of 6 months and the
In the
commissioner-
meantime, let them.
That I handed over that.
Now, my lord,
Amar
now, my
Jana,
lord,
Amar
now, my lord,
Jana,
so far
Amar
this-
Jana's case.
So far this.
Because
this
local
case is
arrangement has
calculated.
to be made.
Kindly-
Your lordship, my lord, keeping the local arrangement.
Kindly seize the
Local
implement order.
arrangement, give 6 months to them. Let
Yes.
I appear.
Rule is this.
What does this matter?
Well, I
Rule is this.
number I can
Now, my lord,
remember.
so far this.
On
My
that
lord, if your
particular
lordship
day.
kindly
Not-
come to
Lord,
the
is
implement order,
concerned,
your
Lord.
lordship. Konta?
The student teacher ratio is 1:60.
Pupil teacher is not applicable to my case itself.
No, no, my
I-
lord, it cannot be now,
Yes,
my lord,
now,
after
after
the
amendment it
amendment
is.
and all this, my lord. How we
Amendment
say
has,
my
does
lord,
not,
that will not be applicable to.
my
me,
lord,
my lord.
kindly seize the implement
Now,
order itself.
government has come up with this policy.
Policy will
nationalization
be applicable to
policy-
the case of the subsequent event. My lord, kindly seize the implement order itself.
We have passed in Amor Jana.
Amar Jana.
Amor Jana, my lord, yes, my lord.
The-
But so far,
definition.
Amor Jana is,
Cases
my lord,
covered-
considering after that Amor Jana, my lord, this 22 circular has, we have, my lord,
His case is covered by Amor
Amar
Jana.
Jana. That is,
yes,
Prior
my
to
lord,
the
but
circular.
his lordship has 2015 circular, but in 2015 circular, my lord, we have modified to some extent in 2022.
Yes, but
His
by that
lordship,
time,
the whole issue is whether it's
23.
prospective or retrospective.
by that time, he has already filed an application and he was eligible to be considered.
yes,
Eligible, and that has been rejected, my lord.
rejected on the ground single teacher.
So rejection was wrong
Wrong.
because this is not in consonance with the existing transfer policy.
That is.
Well, it was
Now,
rejected.
my lord,
It was
my lord,
rejected on the ground of out of 10%.
10% subsequently done.
It is not my lord, single teacher. Single teacher he accepted.
Out of 10%.
Page 2 of the my lord, impugned order. Kindly have a look. Impugned order means learned at my lord.
First one, my lord,
Single
was
bench has-
activated.
Learned single bench has passed an order, my lord.
Page, my lord, kindly come
Page
to.
two.
No.
It is
Not
started,
order.
my lord, the facts has been started. The first transfer application was submitted by the petitioner on August 12,
My lord,
2020.
page 87.
No, no,
Just a minute.
just
Yes.
Kindly have a look at the first page. Fifth line, the first transfer application was submitted by the petitioner on August 12, 2021 before the head of the institution, which was sent back to the petitioner on September 2, 2021 on the ground of single teacher. The second application was submitted by the petitioner on September 24, 2021, which was rejected on the head of the institution on the ground of out of 10%. The third application of the fate, which was impugned in the instant, it was submitted to the petitioner on February 10, 2022, and the head of the institution rejected the same out of 10%. So it was out of 10%. It is true, my lord, the first application was rejected on the ground of single teacher, but that has been accepted by my lord.
But in the
Petitioner
portal,
is at liberty to apply again and again. There is no bar.
What is this out of 10%?
My lord.
What is this out of?
My lord, it was, my lord, teaching strength if there is only 22 application out of 10%, that is 2 persons are eligible for make applications. Now, if the teaching strength is 23, almost that is 2.3, that is 3 persons can be applied. This is the formula.
and petitioner within the 3%, 2% gone, 1% came, petitioner is the third person.
And another thing, my lord,
Not out of 10%.
another thing
Otherwise,
that I
the
want to-
first application could not have been, my lord, reached to the DI.
Now, if his
And
lordship kindly turn to internal page 8, my lord, lordship will find, my lord, at the last, my lord, on account of proposed transfer, taking into account the factual figure that the total strength of the student in the school is 1502 and the existing teacher strength is 25. No, my lord, page, internal page 8 of the impugned order at
Achha.
page 105.
Yes. From the bottom, your lordship.
Absolutely on the bottom, my lord, on account of proposed transfer. Lordship will kindly find, my lord, it has been marked bold on the total strength of the student in the school is 1502 and the existing teacher strength is 25, though the sanctioned total teacher strength is 42. Hence, the PTR is 1:60.
This is, my lord, out of turn.
But how out of turn, my lord?
Submission.
Now, my lord,
Rejection order by the.
my lord, this is the view has been, this is not
How?
permissible.
Court
PTR where
cannot go
transfer
behind the
could be affected.
pleading. No document to that effect.
Now, the existing PIL is concerned, my lord, wherein, my lord, this issue has been agitated and
Entire
the
staff
court
pattern
has,
has been, my
the
lord,
court has decided, Learned Advocate General has submitted that the PTR is now, my lord, is the my lord, the basic criteria with regard to this, and that has been reflected in the circular.
well, the PTR's object of the PTR is to maintain the students. They are the stakeholders, original stakeholders of this system.
The total impugned order is out of, my lord, the fact is concerned. My case is first due to single teacher and second is 10%. No pupil teacher has been, my lord, declared by the authority concerned. Then therefore this impugned order itself, my lord, out of, my lord, that.
No, out of 10%, if it is established,
Yes.
then you see, you have not challenged this single teacher issue.
No, even then I am within the 10%.
No, but still is coming out of.
No, that is the wrong finding of the trial court.
Why? How it could be?
Because of the fact 3 teacher, well, total if 25, then at least, well, higher digit 10 teacher is, well, entitled to make an application as per law.
No, if there are.
Well, more than 20. Out of 10% means, well, 25 teachers, that means 3 teachers are entitled to get application.
10%, this reason was correct or not? That's what you want.
That is their, well,
Out of 10%, Mr. Mollik, was it a?
is not correct one.
Now, my lord, kindly calculate the entire scenario. Lordship will find 1:60 is the ratio. The ratio should be 1:40.
No, no.
Say that was not
we
considered the relevant point of time.
কতজন teacher?
And teachers, it's not about the ratio, it's about the teachers.
Teacher হলে
Teacher is
2.5
25.
25 হলে 2.5.
2.5 means
2.5 মানে 3 teachers are, my lord,
Entitled to.
entitled.
So,
I am
that,
within.
that I have to check with the
so
record.
he cannot be out of 10%.
Get full.
That, my lord, I have to
Cannot be
check.
out of 10%.
Yes.
But whether he comes within 3 and that has to be
My
ascertained
lord, that
from
is
the.
why first time single teacher ground was there. 10% was not there by the DI itself and
Out of 10%, Mr. Bosumoli.
Cannot be done.
This has not been borne out from the record.
yes. And my lord, kindly sees resolution of the DI. School
That is
authority
the reason, my lord, this portal has been suspended.
will not be. My lord, kindly
Then-
come to
Now, then in that case, this out of 10% does not appear to be the correct reasoning.
No, my lord,
Out
No,
of
that-
10%
my lord,
doesn't appear to be the
There is
correct
no
reasoning.
specific pleadings also, my lord.
yes, I have. Page 87 kindly sees. It is the remarks of the school authorities.
Now, my lord, in page 11, my lord, lordship
Kindly come page
kindly-
87.
page
As
11.
per managing committee resolution memo such and such, at present, the members of the has decided, considering the application of the above mentioned teacher, the school managing committee has no objection of the release. And if I within the coming the purview of the 10%, out of 10%, then this observation should not have come. Only single teacher. Even if I goes through the single teacher is not the ground, then I could have been released. And second time 10%. This is also out of track.
No, but out of single teacher, this you have not challenged.
No, I have not challenged subsequently because it's a portal.
Now the second.
Now 10%.
Second ground is out of.
On the date of
10%.
application, 3%, 3 teachers are entitled to get. Now 2 teachers, my lord, including me, 3 teachers applied. 2 teacher release.
Kindly
No,
come
but
to
out
page, kindly come to page 82 once, my lord. Page 82.
Yes.
That is the notification of, my lord, 3rd January 2022 with regard to this 10%. But
Okay.
kindly see,
But I have the specific instruction to that effect.
whereas the
Specific allotment to nahi, kothay?
No, these are all matter of record to be brought on
Yes,
record.
my lord, there is no specific allotment at that moment of time.
2015, just shall consider the total application, not more the teacher strength, provided
The
that
basis of the basis of the order is not disclosed out of.
no, my lord,
10%.
in page 108, lordship kindly see.
Yes.
108, second paragraph.
No. He has, see, the order does not say out of 10, he has to justify how it is out of 10%.
No, my lord,
So at the
here,
relevant point of time, we will direct the DI, whoever is there, to consider the transfer rules as it was existing on the date when she made the application.
lordship.
And to give a reasoned order how this out of 10%, because prima facie it appears that she comes, this is out of.
Now,
10%
now, my lord,
is not
may I
applicable.
just, read once, my lord, in as much as from the meaningful reading of the
Order is
Gazette
not
notification
applicable
third-
to my case. This is
No, my
something
lord,
else.
Here, my lord,
Beyond the track.
sanction strength of that, my lord,
Should
here,
go.
no, my lord, may I just,
These are all matters of record, Mr. Bushuman.
No, I'm not, I was, I was trying to, my lord,
My lord,
may I just-
para 26, 27 and 28 of the planet friends, my lord, apartment. Para,
See whether
my lord,
10%.
10%, my lord, there is a doubt because
Them come with the record.
the application is withholding. That is the allegation.
Not granting any relief.
My lord.
We direct the authority concerned because we said out of 10% is not being clarified. Before she was shown the.
My lord, my humble submission, my lord, if my lord, subject to my lord, what Mr. Murli has said. My lord, this transfer is not that type of right, my lord. Your lordship will hold that since it is a prospective effect, he will get the right.
He has a right to be
But
considered.
at that moment of maybe he has a right, maybe, but now it is not possible.
No.
Right, because his application was, because his application.
I
is
understand, my
wrongly-
lord. I got the
because
point.
his application is wrongly considered.
Yes.
That means that he lost his right. Cannot be.
My lord, now, my lord, this question.
Why the one should come to court of law?
I know, my lord, but now transfer, certain things, my lord, has to happen in, this is not a fundamental right. This is not a fundamental right. My lord, subject to correction, my lord.
They are not
It is true, the government has given some, my lord.
They have not, see, out of.
We are not dealing with fundamental rights.
10% has to be supported by
Yes,
reason.
yes.
If it is contrary to the rule,
Yes.
you cannot support the action. It's as simple as that.
But now, my lord, if it,
Yeah, we are on a, there is no scope for any polemics on this.
my lord,
We have to understand the thing. It has to be on a case-to-case basis. Take down.
Get full, my lord.
then, my lord, also, my lord, kindly keep that view, my lord, the PTR, my lord, cannot be not thrown out. Cannot be, my lord, thrown. That your lordship kindly not do that.
Now, my lord, the last order of division bench of this court, my lord, while deciding this 10C and all these
That was
issues,
upheld.
10C is not applicable to my case.
No, it may be or may not be, we don't know.
that
And
has been,
application-
that
No
has been,
teacher, no teacher has an indivisible right.
That is
to take
there.
transfer.
But my right to be considered is there.
It is right to be
Right,
considered.
under
That's-
10B,
Yes.
this is not 10C.
10B, my lord, I have shown to his lordship.
Much obliged to lordship.
She is a Sanskrit teacher.
Sanskrit teacher.
The apple is arising out of.
On order of the single bench, order of the school authority, holding that I am the out of 10%. First time single teacher.
Page 88, page
Yes,
88.
87 and 88.
Page 88 is by the school or by whom? Out of 10%? This is. by-
Yes. Page
Page 88, column 1.
Right hand side.
No. Who is this person? Who has,
Column number 3.
Out of 10%.
no, out of 10% is.
Column number 1.
HY.
Column number 1.
Column number 1, Miller.
Page 88.
HY.
HOM, head of the
Head of the
institution.
institution.
Service Commission.
What is that order we passed? You have that order with you?
That,
When did we pass this order?
3rd of August, my lord, I cannot
It
recollect.
is the only one, your lordship, third.
No, no, আরেকটা order
Another?
আছে। আরেকটা
আমি তো
আছে,
পেলাম না কিছু।
আরেকটা ছিল।
In your
I
matter.
cannot remember, my lord.
Yes,
I cannot remember now, my lord. Number I cannot remember.
but your name is not recorded in this. Few Patra, you appeared, Few Patra.
Yes,
no,
P. Patra I appeared.
appeared. You appeared for West Bengal Central School
School
Service.
Service Commission.
This is, I have checked up your lordship's all orders.
বললো?
I did not get other than.
আরেকটা আছে না?
না, এটাই ছিল।
Definitely, court order is there.
Commissioner, or the commissioner will be the more appropriate authority. Because principal secretary will not.
Let it be with the commissioner.
Commissioner, yes.
And
বললাম?
Because since it has been issued by this notification and all by the principal secretary.
Subsequent
This
notification.
is subsequent.
হ্যাঁ, বললাম?
Page 75 would attract. Page 75 kindly sees. Time limit for every authorities to be done.
Very well, but
Kindly add this.
there are various,
kindly add.
there are various
Not
considerations.
kindly, let after, even after.
Public, the need of the people. You are not a stakeholder. The
No,
stakeholder
I am
is the
not.
people.
If my service,
There are predominant.
these are consideration, then subsequent.
Online may be added, Millard. This will not be precedent, Millard. Now what will happen, Millard, by showing this, Millard? Now everyone will come and say, Millard, transfer, the order has been
Yes,
passed by this.
rule
court.
tells
Kindly-
me is.
Become a problem for us also.
Only thing also, my lord,
Cannot
your
be
lordship kindly add that the other points should be kept open because the prevalent point law or everything is
Because
all right. My lord, the
Lordship
some
knows the
point should be
problems.
kept open, like people teacher
Cannot
ratio.
be.
That should be,
Rejection
my
order
lord,
not
kept open.
there.
Under the earlier regulation, people, teacher ratio was.
Not there.
considered.
Only 10%.
My lord,
Says
my lord,
that
may I?
Pass an order, he said that he may not be transferred for 6 months or 8 months. And in the meantime,
Yes. Local arrangement is made then.
Yes, that is a
The
provision.
rule itself.
So far the document which I have submitted before his lordship dated 29th of September, Millard, kindly record one line, Millard. This is not the there is no, only 10DB has been referred to here in Millard because of the,
Cannot be done.
reason, Millard. So, Millard, and this has been referred to in the public litigation that has been, that I have my, that has been submitted.
We have not, why you want to?
No, I am not on that, Millard. Since Millard has lordship has passed
If
an
that
order,
is-
Millard.
On the basis of the existing
Norms.
rules and norms.
That is there. Much obliged to lordship.
Deeply.
Get flush.
Get
কত হচ্ছে ওখানে?
My lord, I am for the appellant, my lord. The appellant, my lord. My lord, 20th July, my lord, your lordship pass an order to direct the my lord board to take appropriate decision, my lord. My lord, appellant is the my lord, your lordship. Earlier order your lordship dictate, my lord. My lord, 2014, my lord, TET examination, my lord, he appeared. His result was not published as my lord. Then, my lord, he moved to writ petition.
My lord, only two things, my lord. My lord, one is, my lord, your lordship, my lord, the last occasion, your lordship were, my lord, please to, my lord, ask me. ऑफिसर के बोला
Decision.
ऑफिसर के बोला
Decision টা কোথায়?
not untrained candidate. My lord, first of all, my lord, I tender my unconditional apology, my lord. The heading, my lord, is name of your lordship has, my lord, not properly, my lord. Is my lord, I'm, my lord, paying unconditional apology, my lord. My lord, the predicament is, my lord, that the petitioner now cannot take benefit of his own mistake. My lord, of his own mistake. My lord, mistake in the OMR sheet. My lord, he was not marked the medium of instruction. Suppose your lordship, I cannot, my lord, assess any, my lord, the examining, my lord, that he is, my lord, appearing under, my lord, the giving option, my lord, Bengali or, my lord, Uriya or, my lord, the Urdu. My lord, I cannot, my lord, unless he is given, my lord, option to that effect. Medium of instruction. Unless it is given, my lord, his OMR sheet cannot be evaluated, my lord. This is, my lord, our case, my lord. There is, my lord, number of candidates there for not giving the option. Their OMR sheet was not evaluated because he has come before your lordship, my lord. He got an order, my lord. That is why his OMR sheet was evaluated in the year 2021. My lord, that order, your lordship kindly consider, my lord, the second page, we pass the order, my lord, rejecting his claim.
Not communicated.
My lord, your lordship kindly appreciate. My lord, your lordship kindly appreciate the bottom portion. My lord, the memo was given. My lord, 7361 of 1/3 BTV 2018. My lord, right now, my lord, after 6 years, my lord, they cannot ascertain whether this was communicated to. My lord, this is the, my lord, I candidly, my lord, submit before your lordship, my lord. My lord, not mentioned unless, my lord, it is mentioned that is Bengali. My lord, from the records we have seen
that after the order of Justice Samapti Chatterjee, this was, my lord, the order was passed, my lord, that his OMR sheet cannot be evaluated since he has not, because my lord, we cannot do manually unless my lord court directs. Then they again file a writ petition. In 2021, Justice Abhijit Gangopadhyay was pleased to, my lord, direct board to evaluate manually. Then only, my lord, board evaluated the OMR sheet manually. And my lord, they have seen that he got 104 out of, my lord, 150. My lord, therefore he has passed it. My lord, board allowed him to appear in the 2022 selection process. He gave the interview on 22nd May 2022.
Because you see that
My lord, when Milord,
you have filed the writ again in 2021.
my lord, these.
Well, he had admitted in the writ petition that it is his mistake. Well, he has admitted.
My lord, when Milord, he applied for Milord 2014. My lord, his form fill up that his medium is being.
We cannot reverse the situation. We
But
cannot
situation
reverse-
is that Milord, he is Milord telling that Milord, if the medium is not
No, now
mentioned,
that
then
we
Milord,
have-
he will be cancelled. Milord, there is no such rules of the board that if the medium is not mentioned, his candidature will be cancelled.
It's incomplete form. It's an incomplete.
Not incomplete form.
If you don't,
OMR
then why these columns are there?
My lord, it is also written
there
in
is
the
no
OMR.
Not an
My
endless
lord,
argument
on
on
the
this.
my lord evaluation.
If there are columns are there, you
Yes,
have to fill up the
That's true.
column.
That's
Then
true.
it's an
But my
incomplete.
lord, but
They
my
could have they could have rejected your application on the
But-
ground of incompleteness.
My lord, serial for your lordship, kindly see, my lord, backside of the OMR sheet. Serial.
Now that
4.
you have been called for, you have participated in the interview. Or
but my lord, evaluation of the my lord OMR seat on the basis of the my lord roll number, my lord.
No,
Or these my lord 2018 order they have
have
not
considered the-
communicated.
we have considered
These 24 May 2018 order, they now preparing this showing that they have passed order in the 2018. Kindly see the original call for the record, whether they have sued, whether they are memo register or not.
Next matter, next matter.
এখন বলছি না, নাহলে
The order of this court that trained candidate has a right to agitate any recruitment, they have sued preference.
Yes, next matter.
141, my lord, I am for the appealing the petitioner. My lord, affidavit of service.
Who is for the state?
ওই কোন দিকে যাবো ওদিকে? Mr. Pueli Bhattacharjee, I served copy upon her, my lord. Next time,
She's the answering respondent.
she is the answering respondent.
Because your
My lord, page 48, impugn order. Antonu Majinnath.
There is no representation between
My lord, that representation, if your lordship,
9th January 2023 and
my lord,
there is no
that is
representation in
not,
between.
lordship, kindly have a look into page 45,
Yes, we have seen that.
my lord. I Devasys Pal, such
We
and
have no
such.
case.
My lord, lordship, one thing, lordship, kindly, lord,
We know.
lordship, kindly, lordship,
Sorry.
lordship, well, lordship, kindly, lordship, kindly have a look into this order, my lord. Lordship, my lord,
The appellant is
similar
agreed by the
situated-
order. No, knows that.
My lord, delay is, my lord, here, my lord, delay is condemnable, my lord. I am the successful candidate.
No,
And
this honorable which
my lord,
rules?
continuous
Under
further
which
action.
rules? 4 years, there is
My
not
lord,
a single scrap of paper.
2019.
There is no C. And if you make an application and if it is not been extended, then there is no extension. And you have not approached the court. That's the end of the matter. Take down.
My lordship, kind,
That's the end of the matter. Take down.
my lord,
The petitioner,
2019,
the appellant is
weekend, my lord.
Should interfere with the order passed by the learned single judge. Yeah, no, sorry, no, we cannot. A person who has not come with clean hand, no, sorry.
But with clean and no,
Next matter,
only
matter.
I'm grateful.
not filed the representation timely, my lord.
Yes. We have no jurisdiction.
Lordship, this is not arising out of Lordship section 9 or something, because a suit has been filed. Their injunction has been passed. There they have filed.
But the FMA number which was given subsequently
Yes.
are arbitration. That is a problem.
I'm not sure.
FMA 2 that was given, take it out.
No, no, no.
No, not your case.
No, I am in that matter.
Also, you are in that matter.
This is a wrong. That I don't know, but Lordship, here what happened, I filed a suit, there I obtained an ex parte ad interim order of attachment and injunction. Challenging that, they have come up before your Lordship.
But they have filed 2 applications.
Yes,
It is extending your interim order.
yes. My interim order was subsequently
File
extended.
জানিয়েছো?
আমাদের briefটা কই দেখেন?
Initially, my interim order
But
was
it is-
extended
we have been
subsequently.
informed-
That I have challenged by way of another
We
appeal.
have been informed that other 2 matters, we do not have the jurisdiction. Because these are all arbitration, we don't know. No, but
No, Lordship.
No, no, not the arbitration.
Filed by them, this they served upon us. So section that has been disposed of.
কোথায়- This, the line constable of the appellant submit that there are 2 connected appeals,
Yes, Lordship.
being FMAT ARBA ARB Award 37 of 2023
Yes.
and FMAT ARB Award 38 of 20. So ARB Award is if is there.
No. FMAT number 38 and FMAT. Lordship, that is they served upon us. Lordship, kindly sees the copy. This is the copy of the memorandum. They served upon us yesterday.
এই তো এখানে কোথায় পাচ্ছ তো?
I do not know.
এখানে অ্যাওয়ার্ডটা পাচ্ছ কোথায় এখানে? Some other costed list coming, but if you give FMAT ARB Award, then this costed list coming.
Perhaps one of the CIS has done something wrong while uploading. This is the original memo. ও সবুজ তো জজ সাহেবের কাছে।
না, যেটা কাউন্টার পার্টটা যেটাতে নাম্বার দেওয়া থাকবে ওটা লাগলে ওটা দেখালেই তো হয়ে যাবে।
তো ফাইলিং স্লিপটা তো আমাদের
ফাইলিং স্লিপটাই তো যেটা ডিপার্টমেন্ট দেবে।
তো এখানে হয়েছে অর্ডারটা দিয়েছে
ink slip department has issued.
That number, Lordship.
It's a wrong classification.
Yes.
Wrong classification. Add word on record to properly, I think the computer session, you cannot do it, the computer session has to be classified.
And if it is a mistake on our part in the A form, then we can amend it with your lordship's leave.
দেখতে হবে
With your lordship's leave. And if it is department has done it, then department has to.
Because Lordship, perhaps in the A form, they have mentioned Arbitration and Conciliation Act. That is why, Lordship.
Just wait, we have called for
Mal,
the department. Department কে আসতে বলো, ফাইলটা অরিজিনালটা নিয়ে শর্ট করে আসতে বলো। ডিপার্টমেন্ট কা
142.
My lord, I beg to appear on behalf of the appellant. My lord, it is this matter where, my lord, I, the ex-board president, my lord, the honorable single judge was pleased to hold that the reply under the Right to Information Act was not given, so cost of 5 rupees 5 lakhs was imposed on me. In my absence, I was not a party to the writ petition. My lord, kindly take note of your lordship's last order. অ্যাফিডেভিট সার্ভিস করে দাও তুমি এদিকটা এসো না
Yes, Mr. Who is appearing?
Milord, I am for the writ petitioner in there. I am not responding. Milord,
You have given a Xerox copy, how it can, a cost can be imposed on this.
Milord, it was not my prayer that the cost be imposed, Milord. My specific instruction and prayer was, Milord, to supply the marks obtained by me.
That you have got it by this time.
Milord, we have got, Milord. Subsequently, there is the writ petition is pending. Another direction is there
That's a
for
different-
Milord.
My lord, the only thing I should be candid to your lordship. The application that was submitted to the board, my lord, it appears from whatever documents are there
It
before
does
your
not
lordship.
appear to be under the Right to Information.
It was not at all an application under the Right to Information
How
Act.
it can be a Right to Information Act?
Milord, there was,
Not an application under the Right to Information Act.
Milord,
This application is not an application for Right to Information
We
Act.
got back rupees 500. Rupees 500 could not be there with Right to Information Act application.
but there was a specific notification on the part of the board where the board has stated that cost of application will be Milord 500, that is towards for photocopying and all that.
So
Well-
Right to Information, your application was not for Right to Information Act.
My,
Absolutely, my lord. Now,
Just a minute, your application was not for Right to Information, under the Right to Information Act.
Milord, my application was under the Right to Information Act. I sought certain information.
Where is your application?
তোমার অ্যাপ্লিকেশনটা নেই তুমি বলছো নেই পেজ 32 রিট পিটিশনে তোমার প্লিডিংটা দেখো
No, he said that demand draft is being sent back to you as your RTI application has not been submitted following the guidelines spelled out in the notice.
Milord, they have returned my demand draft saying that my application under Right to Information Act was not as per the specific format.
Right, yes. Now,
Now-
if they are correct in their contention,
Now, Milord, I fail to understand, Milord, whether there is any mandatory format for, Milord, seeking application.
mandatory format.
I do not, in my detail understand.
I tell your lordship
No, we asked you one thing. Under the RTI, is there any prescribed form?
I did not deal with the RTI Act. The notification that is being assailed, my lord, it is not in connection with RTI Act. Kindly come to page 46. Kindly come to my notification. Second paragraph, my lord, in the above context and in the terms of this resolution of the board dated such and such, all concerned are hereby notified that the board will scrutinize the applications to be submitted and candidates on or after the date of this notification dated 20th January 2020.
Lost his or her copy of, yes. If he has lost his or her copy of the OMR. Now, what is your application?
Milord, it is not my appeal, it is their appeal.
No, what is your application?
My application was specifically restricted to, my lord,
Page.
Milord, the prayer portion of the writ petition, your lordship.
No,
will-
My lord, I should
Just a minute, where is your application?
Will the RTI application? Well, it was not annexed with the writ petition. Milord, I tell you, lordship, At present, I am not here to oppose the appeal of this.
No, not at all. If you have not disclosed the application by which
Milord,
you have asked for the informations, because you see this 500 rupees
Milord.
was for a particular purpose.
Milord,
Now, these are none of the purposes.
Milord,
for
I
which
tell
you
you,
have-
I absolutely bow down, your lordship. I understand, Milord. What happens, Milord, the petitioner has, Milord, has made an application under right.
Now, you are only trying to understand, appreciate the reason for the cost.
Milord,
Now, if
I
it is not,
understand.
if you have sent rupees 500,
Milord,
then it is only for the purpose of the notice of 2021, 2022.
Milord.
So this is your application is not coming within the purview of this notice.
Milord, I tell you, your lordship. Milord, the petitioner appeared in the TET 2017, Milord, selection process, the written examination, not the selection process. Now, Milord, she subsequently was declared as an unqualified candidate.
Unqualified.
My lord, she could not appear. My lord, thereafter, my lord, there was a notification on the part of the primary board, my lord, saying that those candidates who could not qualify the written examination are given an opportunity to make an application under Right to Information Act,
I see.
seeking, my lord, their marks of.
So your application was under the wrong premise, because you have sent 500 rupees.
No, my lord, there was, in the notification, they have also stated that cost of application will be 500.
Which one?
My
Which
lord.
was?
Page 46.
Milord, will kindly comes to page 46, my lord, of
Yes.
scan 3. My lord, the notification has been annexed.
In the above context, in terms of the resolution of the board, all concerned are hereby notified that the board will scrutinize the applications to be submitted to candidates on or after the date of this notification who lost his or her copy of OMR. Now,
My lord.
you are coming within this purview.
Absolutely, my lord. I appeared in the TET 2017 written examination.
Yes.
I could not qualify. That's why in terms of this notification dated 20th of January 2022, I was given an opportunity, my lord, to seek my OMR sheet and the marks obtained by me. Now, my lord, there was certain proviso. I was to deposit 500 rupees in order to obtain those, my lord, OMR sheets. Perhaps it is for the cost of photocopying and, my lord, other expenses. Now, my lord, I make that application. My application was not replied to, my lord. Accordingly, I filed a writ petition.
No, first tell us. It requires, suppose if we come within the purview of 2022.
My lord, 21-22 is for the selection process. I am not on that.
But which one is you are not being able to show us which application you have filed.
My lord, I tell you, lordship, my lord, what has happened. My lord, I made the application.
Yes.
What has happened, my lord, petitioner is a resident of an outskirt remote village. She doesn't have the office copy of the, my lord, her copy that was sent to the board. Now, my lord, admittedly, from the letters, those are annexed here too, there is a whisper of, my lord, application that was made by the petitioner.
Where?
My lord, since, my lord, the board has returned the draft saying that your application is not as per the prescribed format. I am saying that there is no prescribed format.
As your RTI application has not been submitted following the guidelines.
My lord.
My lord, an official of the board has used the term right to RTI under the Right to Information Act. Now, my lord, kindly peruse the notification. The notification does not say that the application under Right to Information Act, any format is being prescribed. Notification does not deal with
this notification does not apply to him. He said, I have not applied under this notification. According to him, he has.
If he has not applied under this notification, then he ought not to have paid rupees 500.
No, well, I have applied.
No. He may not. He may have wrongly paid 500. Let us assume. 500 is payable.
Both cannot go wrong together.
500. He says that even under the RTI notification, there is a requirement of 500 rupees. That is what he said.
No, my lord, I am not able to convince your lordship on this, my lord. Pursuant to this notification, I have made the application under Right to Information.
Pursuant to this,
my lord, since I was given an opportunity,
treating it to be,
my lord, and my lord, there was, my lord.
Now, my lord,
take down.
My lord, two more grounds. One,
we have heard the land counsel for the parties.
Petitioner is a resident of a remote village.
Yes, we understand.
purpose of the writ petition has also been achieved, subject to correction.
That's for them to decide.
Milord, since the writ petition is pending, Milord, I intended to, Milord, ascertain my marks as well as the OMR sheet. Well, only the marks has been given to me, Milord, not the OMR sheet.
Lordship, the digitalized data, I think that has been served to the.
Well,
Lordship.
Milord, in my
In the
application.
prayer, it is digitalized data.
But to dispose of your writ or anything else remains?
Milord, only the thing, Milord, the OMR sheet. They, for some reasons or the other, they are not disclosing the OMR sheet in my connection. Since there is an order, Milord, I believe, Milord, they will do it.
So should we dispose
Milord,
of-
only direct the board to supply the, Milord, OMR sheet.
Lordship, that has already been directed.
the board is directed.
Within 2 weeks, that has been directed, Lordship.
OMR sheet টাই দিন তো। Milord, there will be a confusion
As paid in the
with
writ petition, Lordship.
Milord, there will be a confusion with regard to
Page 30.
OMR / digitized, because they will say, since there is a option, they will only provide the digitized data. But my specific prayer in the application was supply of OMR sheet. I want the
Lordship.
hard copies of the OMR sheet.
But if they have been
In
digitized,
respect,
Milord, if they had been digitized, as per the, Milord, directions of the court and the earlier orders, Milord, we find that all the digitization was done by a third party.
My lord,
So,
it will be my duty, my lord, with regard to providing of OMR sheet, my lord,
But he is no one to the board, Milord, at present.
I have already preferred an SLP and on this issue, my lord, an SLP is pending. This is only.
no, but OMR should be.
Lordship, original OMR of 2014 and 2017 is not available. That is on record, and the issue is pending before the Supreme Court. And CBI is inquiring on the same, and we are providing only the digitalized data, Lordship.
2017.
2017 date.
It was.
And we are providing only the digitalized data to anyone asking for the same.
But if that issue is pending, then we are.
Milord, if the issue is pending, Milord, I have nothing to, Milord. I shall not stand in the way.
Can provide the digitalized data that we will provide.
We direct the deputy secretary to supply the
Because in the prayer only, the petitioner has made page 36, OMR or digital? Digitized data. Prayer B, Lordship.
/ digitized data sheet
It is his prayer.
petitioner
It is there. So why should I
pertaining
not
to
do
her
it?
written examination of date
আমি তো OMR টাই তো
2017,
চেয়েছি।
held on 31st January 2021. Party at your stage.
But he is a party. He, pursuant to direction of the learned single judge, Milord, he has been made a party to the writ petition.
You have two appeals.
My lord, subsequently, I have been made a.
I have been made a party. I have amended the constitution.
The learned counsel for the parties have submitted that in view of the aforesaid order, nothing.
With regard to supply of the OMR sheet.
Not supply of the original OMR sheet. Availability of the original OMR sheet.
না দুইটা সেট আছে না না the learned counsel for the appellate for the board has submitted that supply of the original OMR sheet for the relevant year is pending before the Honorable Supreme Court. In view thereof, for the time being,
Page 36, Lordship.
যা আছে প্লেনে তাই তো হবে, তার বাইরে যাবো কি করে? পার্টি করলে
OMR slash, OMR, no, QLM. The digitized data sheet of the OMR
Lordship.
pertaining to her written examination shall be supplied within 2 weeks from date. The acceptance of the said digitized data sheet would not prevent the petitioner to pray for production of the original OMR subject to the result of the pending SLP. The learned advocate for the writ petitioner has submitted that not satisfied with that,
Milord,
then you have that
if ultimately the Honorable Supreme Court's order is in my favor, Milord, then I shall not.
Again, you can ask for the
Then you cause that.
grateful, Lordship.
তখন একটা কাজ
Same Milord.
Since I did not deposit the cost, all my properties were attached.
now because this is allowed, so you're
So my lord, kindly pass it
take
forward.
the issue.
হ্যাঁ
সবাই আছে।
You are the writ petitioner there.
Milord, I'm also there. Same writ petition, two different orders,
Same
Milord.
writ petition, next date, my lord, 27 February on returnable date. My lord,
Sir.
since I did not deposit the cost, all my property.
In view of the aforesaid order, as 2023, the impugned order is set aside. In the same writ petition, two orders.
Same writ petition.
Twenty-seventh February 2023.
27th February 2023.
I was formally citing my lord R.K. Jain, but it did not require.
Okay, Jain, what
R.K.
happened
Jain
now?
statute. My lord, that CPIO is only the
CPI?
the CPIO is only the responsible official. I also.
Grateful, Lordship.
My lord has been obliged to set aside the order.
Yes,
Yes.
My lord,
Attachment order, second order, sir.
set aside the attachment order.
no, my lord, is the mistake concerns me?
No, 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 no.
Oh,
Yes, your mistake. You have wrongly classified. How you can classify it as an arbitration?
It's our fault.
মানে ওখানে করে দাও ওই বাট যে নাম্বারটা তো অন্য হবে with a fresh number. With both the appeals should be assigned with fresh
Wakalatnama in connection with
Yes.
those new number, Lordship.
Leave is given.
Yes, yes, yes. And I'm not being paced, my lord. Perhaps my lord has suggested the name of the arbitrator. My lord. My client is only, my lord, does not have any objection to the arbitrator, my lord, only about the remuneration charges, my lord. If
We have not fixed. The arbitrator shall fix it in the first sitting of the court, the first sitting of the proceeding.
and if my lord can consider my lord,
No, no.
any senior advocate of
Under the act,
any senior advocate from
Fine.
this.
Lordship, that we have objection because appellant number 2 is an advocate.
Would your lordship will sit, so far the, after recess, this bench will
we
continue.
have a bench, I think I am
Yes,
already late.
that we know, there is
Yeah,
one matter.
I think we'll be sitting at 2:30 because now it's almost.
Yeah, that's
2:02.
true.
Then I have a bench with Mrs. Pitato. If that appeal goes, then of
Yes,
course.
yes,
possibly
yes,
no.
yes. Now, only, my predicament is,
So, if you are not there, we'll simply attend.
so, the least, thopar, my
Yes,
item
yes,
one
very well, no
forty-seven, that will
No,
remain.
we'll take care of it.
Get, much okay.
Deeply obliged, my lord.
Yes. Look up mutually.
Item number 1,
Yes. How was that?
Sir, I have inspected the LCR, but 200 or more pages have not been sent across from the district court to this high court. I have prepared a list of omissions and discrepancies on affidavit.
Yeah. Which was it's a report of it. It's a report code. Board record থেকে না থাকতে পারে। These are all LCR. LCR is there. It may not be from your record. That's a different issue. LCR contains all documents.
No, sir. The enclosures along with the petition is not there. The enclosures along with the chief, evidence in chief, that is not there. Secondly, there is a CD. Material was presented in electronic format. There was 2 CDs. One CD was presented by myself and another CD was presented by the opposite party. One CD it is not clear whether the CD has been checked. It was presented almost 8 years ago. It may work, it may not work, but I don't know whether it has been checked.
So that is being exhibited or not?
If one CD is exhibited, that CD is not even part of the LCR.
The CD has not been, no CD was exhibited.
Yes, sir. It is exhibit 8. It is exhibit 8 in the chief submitted by the opposite party in the district court in July 2018. It was marked as exhibit in red ink. That also I have seen in the LCR, but it is not there in the records sent from the district court to the Honorable High Court. And secondly, even the CD ought to be checked because it was presented 8 years, 5 years ago. It may work, but it has to be checked.
এই শোনো, এতদিন ধরে ম্যাটারটা শুনছি। এটা কি সিআরটা কি কম্পিউটার কি আমার নোটিশে তো মানছো না। কি আছে এলসিআর কারেকশন জন্য সেন্ড ডাউন ফর কারেকশন অর্ডার হয়েছে?
Where it is supposed to be there. Those page numbers are also there in my affidavit.
डिपार्टमेंट के लोग के रखो LCR डिपार्टमेंट
The custody of the child.
It is, there is a irregularity, sir. If you allow me, I can explain.
Regard to the custody of the child.
Evidence in connection with an application under section 26.
Did you tender any document?
But in the suit, there are only 9 exhibits.
Yes.
We are also hearing the custody matter, isn't it?
Yes.
The custody matter, the main matter has been.
No, that's why this file, these defects are in relation to the custody matter.
Oi, miscase under section 26 of Hindu Marriage Act was there. Here he.
While hearing the custody matter, the learned judge feels that the main matter should be disposed of. So, my lord, he has taken up for hearing of the main.
So this exhibit 8 series, that is 6 photos, and then these pages of exhibit P are all in relation to the custody matter.
Yes.
No, but we are hearing presently the appeal from the decree. So all documents are there so far as the appeal from decree is concerned.
No, sir.
Yes, all the 9 exhibits are there. There is no defect on that. These are the only exhibits. These are the only exhibits by them. You have not exhibited a document, so that cannot be taken note of. These are the only 9 documents. So this is final. So you cannot say that.
So this is section 26. This is section 26. This is filed by me, not by the opposite party.
ডিপার্টমেন্টে দেখেছো?
Order.
সিম্পল জিনিস হলো
Both, sir, because there was one single order passed for all the issues in one fell swoop, but that is a different issue. It will contentious that I have to argue.
The custody is also there, Mr. Roy.
Yes, custody was there.
The suit were hard together.
Yes. It was in one fell swoop, the entire order was passed.
এটা কে দেখেছিলেন আমার ঘরে কে গিয়েছিলেন কোথায় ডিপোজিশন করে এটা দেখিয়েছেন আপনি সামনে 11
Yes, yes. Now, my lord, kindly, my lord, I'm sorry, my lord, kindly, if you lordships kindly come to page 140, 140. Order number 41 dated 11th February 2019. Both parties file Hajira. PW1 Shamastri Basu is cross-examined by the learned lawyer for the opposite party. Respondent also filed a petition praying for time, allowing another date for cross-examination. Prior for time is allowed, and the cross-examination is deferred at this stage. Fixed 29th March 2019 for further cross-examination. Then, my lord, 29th March 2019 order, my lord, both parties are present. DW1 is cross-examined in full and discharge. Application filed for evidence copy is seen. The petition is taken up for hearing. Both petition treated Peru treated their, I do not know what it is written. Further corroboration is not necessary. Just to delay the case, their petition is filed. It is rejected. The evidence of DW1 is closed to 30th March 2019 for making for hearing of argument. No time shall be allowed in any manner. Now, next order number 43. Today is fixed for hearing arguments of the application under section 36 of the Hindu Marriage Act. Parties filed Hajira, heard both sides, fixed 1st April 2019 for delivery of judgment.
So this is all section 26.
Yes,
This is all section 26.
I am saying that. Now, my lord, kindly come to my lord, page 143, order number 44, dated 1st April 2019. Both parties are present by filing Hajira. In course of writing order, it reveals in course of writing order, it reveals that the points as urged in the petition and written objection are the subject matter of the whole suit, and the matter was heard and the same will dispose of along with the suit. So, my lord, section 36 was finally heard. Judgment was reserved, but my lord, at the time of delivery of the judgment, the learned judge thought that the main matter should be disposed of when the section 36 will be also disposed of. The record shows that both parties filed respective documents along with pleadings. So, I am fixing a date for reconciliation, and if fails, issue will be framed on the date. The parties are directed to appear before the court on the reconciliation to 4th April. Then, 4th April, petitioner files Hajira.
Have for the purpose of deciding your appeal against the decree.
Yes.
The pleadings are complete. You have the claim, you have the written statement, you have the affidavit of evidence,
Yes,
and
sir.
the depositions. You don't require anything else.
So depositions, all the depositions I don't have. Some of them are in the LCR. Secondly,
Why you have not obtained the deposition from the LCR?
yes, sir. Firstly, I had to report to the court that there are some 200 or more pages missing.
So you come to that for
Yes.
the purpose of appeal from decree.
Yes, sir.
Claim, written statement, affidavit of evidence filed by any of the parties,
Yes, sir.
the depositions, and the judgment. That's all.
So the plaint contains the several enclosures. Those enclosures are not there in the LCR. Then
Those were not admitted into evidence as well.
but they were used for the court performed discovery of documents based on those.
Only those documents which were admitted into evidence, that will be
We are
considered.
only considering that. We are not considering any other document.
So even the other side had marked has marked other exhibits also as part of the section 13 chief.
Whatever
Yes.
was formed part of affidavit of evidence, affidavit of evidence. Which page is?
P13, P16 of the stay application.
My lord, may I indicate one thing, my lord? If your lordships kindly come to, my lord, page 145. Kindly come to my lord, page 145. Have a look, kindly. Now, my lord, this is the order dated 6th April 2019. 6th April, have a look, 6th April 2019, order number 47.
6th April, yes.
Yes. Now, my lord, kindly come to the lower portion of the order, my lord. Fix 22nd April 2019 and 23rd April 2019 for examination in chief and cross-examination of the petitioner, and 24th April 2019 and 25th April 2019 for examination in chief of the respondent and cross-examination. Parties are directed to come ready on those days. Thereafter, my lord, he didn't appear, took time. Now, kindly come to page 146. Similarly, my lord, now what he is doing for the last 2.5 years before these.
There is a decree. So he has challenged them.
Yes.
So plain written statement, evidence in affidavit evidence, affidavit on evidence, and the documents and the judgment. 5 things are required. So because the plain is there, statement is there, chief is there. Where is the chief page?
Now, my lord, the order which just now I have placed before your lordship, that could not be, my lord, held because, my lord, he didn't appear.
So I will argue on that matter. Let us argue on that
Yes,
matter. when
challenge
time
the
comes.
decree.
Yes, definitely. But so, my lord, the examination in chief, or my lord, the cross-examination will be not here. The deposition will not be here.
Has to want to challenge, then he has to challenge the decree on merits.
Yes, yes.
The law is settled on.
Yes, yes.
So if he challenge the decree on merits, then we have to hear him on merits on the decree, not on any peripheral issues. এই তো চিফটা দেখলাম কিন্তু এখানে এতে exhibit 1 এই তো আছে এখানে
Exhibit 1 that was suggested by the deponent may not be accepted by the court.
হ্যাঁ সে তো আছে আমি দেখছি এখানে আপনার এই যে exhibit এটা দেখছি না
Sumit Babu, order sheet lower court.
All records are available. There is no lack of any documents. You argue on the merits.
Okay, so actually there is a, the chief, evidence in chief.
Yes, that is
is-
there.
is
Page
in-
156 onwards.
Yes, sir. It is inseparable from several documents she has mentioned as paragraphs.
Yes,
If I have to
there are
read the paragraphs,
six exhibit. Yes, please read it. The evidence on our chief is there.
there are 100 pages along
No,
with
no,
the.
Mr. Basu, only the documents admitted by the learned trial
We are
court
only
should be
concerned-
considered.
Nothing
Nothing
more
else.
than that.
I understand that, but if I have to read out that page, and if the court asks me, where is this document, I will not be able to answer.
No, no, no. We
Because-
we are not in need of anything other than the documents considered by learned trial court. We are to see whether
So then it may be a question whether those documents should have been admitted in the first place.
You
Because
argue,
there has-
on that.
There has been a, because her statements
No,
cannot
very
be
well.
separated
We'll
from.
hear you on that. You argue on that these documents should not have been admitted to
No,
everyone.
not should have been. The documents which are not there today should have been as part
Then
of.
it has to be, if you want to have these documents marked,
Yes,
then it should have gone as your exhibit
yes, sir.
by either going to the box or putting those documents to the plaintiff.
I did not even get the chance. Even before I got the chance, the case was
That will consider whether you got the
disposed-
chance or not, that will
was
consider.
disposed unchallenged. So
That will decide, but
you have to make out your case before this court.
yes, sir, I have written that. I have written
Yes,
in
you
the
make
memorandum
out-
of appeal
make
also.
out your case. Yes, we are hearing you. Please start.
So, sir, in order to do that, I have to, firstly, then I have to include some of those documents as
You
part of
can't
the
include
paper.
anything. We are only concerned with the plaint, written statement, chief,
Sir.
6 documents, judgment, nothing more than that.
The plaint is inseparable from documents she has submitted, and she has made
Yes, 6
claims.
documents, correct.
No. The plaint was submitted in 2012.
Those documents cannot be taken into consideration. They are not relevant.
So then they should be brought out in my challenge, because otherwise,
No, you cannot brought it out the challenge because you did not adduce any evidence.
sir, I did not, because I did not get the opportunity to do that.
Yes, very well. You argue a point. Start.
So then I have to
Mr.
prepare.
Basu,
Yes, sir.
Mr. Basu, this is the opportunity. You make out your case.
If we feel, we'll send it.
We
Send
can
it
send it back if you can make out.
Sir, on merits, I can make out.
Yes, you have to.
Sir,
That is
then
why.
Let me first prepare a paper book and law notes for it. Because I have not even, I was given the opportunity to inspect the LCR and
Yes.
create a paper book. So I found the LCR is 200 or more pages are not there. So that my duty was to report it to the court. I have reported it court to the affidavit today. And then there is this exhibit CD also. That CD is not there, even though it
It
is.
was not admitted.
No, it is exhibit, sir. It is.
No,
It
no.
was not admitted.
It is.
6.
Okay.
Please
Sir,
have a look at these 6 documents.
These are the
Beyond that.
documents considered by learned trial court.
That's all. We are confining ourselves to that only. These documents only. We are not traveling
no.
beyond it.
it is dated to 2018, sir. 2000.
It was
We are
not considered.
We are not concerned with any 2000. We are
No,
concerned
no,
with
2018. She has marked many exhibits. The court has marked exhibits.
that may be in connection with some other proceeding.
To 26,
in
section
the- in-
26.
no, in the-
Section 26.
We are in section 13 matter.
Both section
So in
13 to section
no, no,
26
maybe
are.
that is for custody. We are not on the custody. Custody or alimony. We are not going on to that. We are only considering your case for the time being. You address us on the merits of your why this decree for divorce should be set aside.
Sir, I have challenged the order dated 29/5/2019.
We have decided 2 things.
Yes,
One
sir.
is the suit was decreed
Yes.
and the other is child custody.
Yes, sir.
So first we want to hear you on the decree for divorce.
So will the other part also be heard in the next?
Separately, yes. So you
Okay, so in that case, it is my humble submission that for that matter, there is an exhibit which has not been transferred from the Sialda court to this court. There is exhibit. I am talking of hardcore exhibit.
okay. This
It is a
exhibit-
CD. It is a CD submitted by the other party in July 2018.
So it is an exhibit marked as exhibit in red ink. I can show it from the file. It is not there. It is not there. It is in the blue file. It is in the blue packet. Yes, in that page, number 8, serial number 8. There's a CD.
There are 2 CDs.
That is, I have submitted it, but they also submitted, but it is not there. And that is marked as exhibit.
This was with regard to your custody matter. This
Yes,
has nothing, so we are hearing you for the time being.
Yeah, but whenever it is heard, it will be a
Then you take
omission.
care of it. So you first address us on this.
So will the order be passed to retrieve that CD from the court?
We'll consider it. First, we want to hear you on divorce.
Yes, sir. So for section 13, then I have to follow the procedure. So I have to follow the steps accordingly. So today I have reported the
We have
matter.
all documents are on record. We can hear out the matter. There is no lack of documents which can prevent
Yeah.
that.
So then I'll prepare a proper paper book, volume 1 and volume 2. And then that is the instruction I have been given. So
Not required.
that is the instruction I have received from the
We'll
court.
dispense with that.
So I don't, it will be very, sir, I humbly submit, let us look at the volume of this. It is 3,000 pages, 2
You are
feet
not,
tall.
that is why you have to absolve you from this unnecessary expenditure.
No, I'll not
So
go through, it may not be fully, I mean, I'm.
No, so you have all the papers and you have also all the papers.
I understand that. I
So
have
you
then have
don't
to
require
first
to
of,
file an affidavit.
it will, I have to first bring those papers in and it will be a nightmare.
Don't bother about it. We'll take the trouble. You first address us on the merits of the matter. We'll take the trouble. You first address us on the merits. Now tell us what the plain case is. Where is the plain? Tell us. Which page?
Sir, even law notes have not been prepared.
Not
because I have
required. Not required. Please tell us where is the plain. Plaint you have annexed. Plaint is at page 20.
Plaint is P1. It is P1 of the stay application.
Yes. So it's there. Please tell us.
Yes, sir. I have not been prepared also because I have to. The instruction to me was to create a paper book, volume 1, volume 2. So I have followed this instruction. Basically, I have first inspected in order to go through that, I have first inspected it. After inspection, I have reported to the court duly that these are the things I could not find.
No,
without the paper
you see,
Yes, sir.
your stay petition contains almost everything. Please come to, you are prepared, you are appearing in person. So you are conversant with this. Your plaint is at page 16. I assist you. Please have a look at this.
I don't have the file today, sir.
Why you are not carrying the file? You are appearing before us when the appeal is fixed and you are not carrying the file.
Sir,
And you make us to believe that you were diligent before the trial court in pursuing your matter.
Sir,
With this conduct,
Sir,
you make us to believe that you were diligent enough to proceed with the matter
Sir,
before the trial
I was
court.
prepared to create
And
a
we
paper
have
book.
said,
Yes, sir.
we have made it clear that this is the order of 21st July for your benefit. He appears he has submitted at the time that given on after going through the record, he observed that since all the relevant documents have been included in the state application filed by Mr. Basu, the same is treated as paper book for the purpose of hearing that.
Sir, I respectfully disagree with that because it will be like
You
taking
disagree with what?
that it is
Our direction, you disagree with our direction.
Sir, I have written in the CA9 also.
Want you to argue. If you don't argue, we'll close it and finish off the matter.
Sir,
It's up to you.
It will be a
You
miscarriage of
cannot,
justice.
no, absolutely not. We have shown you enough intelligence. This is our order of 21st July.
If the paper, if the
You
LCA
don't
is
have to
not
find a
involved,
paper
it is
book.
not
That
my
is our
fault.
order. We dispense with you from filing the paper book.
Then it will be a nightmare to argue the matter 3,000 pages.
No,
2
you
feet
don't
tall.
have to go to nightmare. This state petition contains everything.
That is a perception created by the bench, but I may have a different way of presenting my case.
You
How I will
cannot
my
present
case?
your case beyond what is there before the trial court. You
Yes.
have you have the plain,
Yes, sir.
you have the written statement, You have the evidence on affidavit, you have 6 exhibits and the order.
In the stay application itself, I have stated
No,
that I
you
will
ca-
create a paper book.
We have dispensed with this paper book in our 21st July order. We have dispensed with this.
So then my argument will be broken and my
No,
argument
will not be
thread of
broken.
argument
No,
will be
absolutely
broken.
not. Your stay petition is here. Your stay petition is here.
I'm not sure how that perception has been created by the bench, but I have never said it. The
The
bench,
order,
the bench
you
has
are not an
perceived-
illiterate person. Can you not read our order, what the order says in simple English? What does it say on 21st July?
So then CA9,
No, what does it say on 21st July?
after
Mr. Basu?
CA9 is there.
What this 21st July order says.
Sir, that is why I'm CA9. I have written, I need a paper book.
No, you don't need a paper book because you have filed a stay petition which includes everything.
So then
Not allow you to delay.
So then let the court pass an order. I have to work according to the law, because without a properly allowing me to
order, why
present
should
my
we go on
case-
repeating the orders? 21st July, the order was passed.
So then why did I even inspect the LCR? I didn't
wanted to inspect the LCR, so we give you permission.
So there is no need to inspect the LCR then.
Yes, hold on.
We must stop from abusing the procedure. আমরা হিয়ারিংটা কন্ট্রোল করবো
In that case,
In section 26, sir, around 10.
9. These are the 9 documents. 6 documents were admitted at the behest of your wife. Those documents are with the court. What else is required?
With respect to section 26, it is there. Yes.
No, in respect of both. In the
Suit
other
is
are
also.
6 documents already on record.
Yes, sir.
Then what is else is required? Nothing else is required.
Yes, sir. In that case, if the other, I would have preferred to.
We cannot go beyond what was considered by learned trial court. Right? If you can make out a case that those documents are required to be considered for proper adjudication, then only we will look back. Otherwise not.
Sure, sir. Sure, sir.
So you need to assist the court here and now.
Yes, sir.
Justifying the requirement of
those 200
yes.
pages. Definitely, sir. I will definitely do that.
200, 500, 2000,
Yes,
whatever.
Sir. Yes, sir. I can do that.
So
I can do
assist
that.
the court.
It
address
is,
the court
it is,
right.
my goal is to assist the court. And without those documents, I will not be able to assist. So that is why I am trying to bring up this matter.
Here only confined our attention to the documents exhibited. Whatever documents you have exhibited on your behalf and on their behalf.
Yes, sir.
We are only concerned with that.
Sir,
you have not filed any affidavit of affidavit in chief in the suit.
Section 13, I have not filed. Yes.
So if you have not filed, the only document you have filed about 9 odd documents in the child custody matter. All documents are here. So far as your divorce proceeding is concerned, 6 documents, all are here.
Yes, sir.
So you have to say that on the basis of these 6 documents, the case of the wife is not proved. Matter ends.
Sir, if that is there is one irregularity that was committed by the other side. So, and I do not know whether the court, district court, at all detected the irregularity or not. Is that in her chief, she has marked documents as exhibit in her residence, and even before submitting in the court, and she has submitted in the court. So they are also marked
those
as
documents
exhibit.
were not admitted. A to Z.
Yes, sir.
Those were not admitted.
Only 1 to 6 were admitted. In court, marked as exhibits.
But it appears from the order that the court has taken into consideration those documents. That I can prove. Yes, sir.
So may I submit one thing, Malad?
The
So
order
the
makes it clear from the
marking
language of the order.
Marking of documents of the wife 1 to 6, or Malad, the marking of documents of Mr. Basu. Malad, the court has no occasion to consider while the judgment was delivered, because Malad, he has not participated in the proceedings.
Not true. Even in an ex parte order, the court has to take care of the documents.
Now,
that cannot be.
No, Malad, kindly see, Malad, the way he is proceeding before this honorable court, in the same way he has proceeded before the trial.
Fine.
That is irrelevant.
Now, Malad,
But to adjudicate the issue, court was under obligation.
now,
to
Malad,
consider
that's
the
why,
documents.
Malad, I want to show to your lordship the order passed by the court.
Let Mr. Basu finish.
First, we are hearing on the matter of divorce proceeding. There are 6 documents were there he has not exhibited documents. So we are first deciding on the, please tell us, because that both the matters record is complete. So you address us first on the divorce.
Sir, if there is okay, sir, with all humility and respect, I also draw your attention to CA 9, which was submitted on the previous date, and it is not disposed as yet. So my contention before the court was that I with full respect, I am saying that I have moved the Supreme Court for certain directions in proceedings, for the proceedings of this case. And the matter is coming up on 14th, which is next Monday. So I would be grateful if at least I get an opportunity to bring it up before the Supreme Court. And then whatever the Supreme Court says.
Is there any order of stay?
The order of stay was not there. That is because there was mediation. Over the last 3 months, there was a mediation. I did not move the court when the mediation is going on. Now they have dropped out of mediation. I moved the court again.
We have been pretty clear in our order of 21st July.
Yes, sir.
That we will not grant any adjournment.
But CN9 has not been disposed. CN9 has not been disposed.
CA9, what was your CA9?
Before this honorable apex court.
An adjournment petition.
Oh, it is an adjournment petition. Yes, so impliedly rejected. This CA9 is impliedly rejected by an order of 21st July.
No, sir, it is not stated in the order.
No, impliedly rejected what we have asked for. Graciously please to adjourn the matter of a scheduled hearing on the aforesaid SLP and to allow the inspection of LCR and allow compilation of paper. We have said Mr. Basu will inspect. So part B was allowed, part B was allowed. And so far as we said that on such and such a going to record, we observe that since all relevant documents have been included, the same is treated as paper book for the purpose of hearing. So A and B was rejected.
Yes, sir. But the A and B was addressed. It was allowed. It was allowed actually. But the
Allowed, A is rejected. Yes.
but the A was not. There was no specific order on the
No,
Supreme Court.
It's very much specific that you will be hard to do no adjournment. It is very specific. Choice is yours. If you want to argue, argue. If you don't want to argue, we'll conclude the hearing and pass on the basis of the evidence. Choice is yours. We will not go. We cannot go on like this. All documents are here. All documents are here. So if you want to argue today, you argue. Or if you want to argue tomorrow, we can fix it tomorrow also. We have no problem. But
Sir, in such a short time, I'll not be able to prepare the law notes also, let alone I mean, any
when you
structured
file-
format.
when you file this definition, you must be aware of what is your case is.
Lot of Supreme Court judgments have come after that, which are necessary.
Give us a
Then
list of
there are also lot of
what which issue.
on both section 26 as well as in general on the.
We are not here on an academic discussion.
No. It is applicable to my case. It is
So
applicable.
tell us
Yes. So I may have it.
a lot of judgment that
Yes.
you are aware of the judgment.
Yeah,
What was the proposition? Which proposition you want to say to that?
So I have
What
to,
proposition?
I have to jot it down on pen and paper, and then
You will come ready when you know that 21st July is the date fixed, the date fixed is today for, and no adjournment shall be granted to you.
it is my duty to first inform that I found some papers not there in the LCR. I cannot put the cart before the horse.
So you conclude your hearing, file your law notes, we'll consider it, no problem. Before you deliver the judgment. Conclude your hearing, tell us. Or you come tomorrow and address us on this.
Tomorrow, sir, it will be. I mean, in 6 hours, I am not even a legal.
How that since you are particular matter, it should be on the tip of your finger. So facts are in the tip on the tip of your finger. You must be the laws also on the tip of your finger.
Sir, I am fighting 3 cases: Bangalore, Calcutta, Delhi.
You are not concerned with that.
I have to earn my livelihood also.
You are required here because your presence.
I cannot go beyond the limits of my physical strength.
Your presence was so difficult. So now that you appear, you have to conclude because our order is very clear on this.
I have to earn my livelihood also. This way, my livelihood is lost
No,
because of these 3 cases going on.
You have completed the argument. You don't have to come to us again.
No, sir,
Finish it. We are giving you the opportunity to finish it up today.
if I
Finish it up to 6, no problem.
if I finish it by any which means, it will be a I mean farcical exercise.
You want to cite certain judgments.
Yes, sir.
You come back with judgment, finish your argument.
It is there's a thread of argument. I mean, I cannot just say
Hearing
I mean,
on both.
take broken pieces and join them together.
No, what are your points? You have to formulate your points. You tell us. You must be aware of this.
What will happen is if I make a partial argument today, it will. Sir,
It takes 2 consecutive days to finish your argument.
Sir,
There
then,
are enough 2 consecutive days.
sir, then kindly give me 1 month time. I'll create the proper notes.
No, it will be our time. If you will give you 2 consecutive days, we'll sit, finish it up your mind. Take it.
Yes, sir. Kindly take it on the 1 month later, sir. 2
No,
consecutive
sorry,
days.
no.
I'll do that.
Sir, Manojit Basu, the appellate
exhibit P. Exhibit P is which figure? Nothing. It's in matrimonial suit, custody matter.
So we say can your exhibits. And P is also of course you. There are a few pages in the custody map.
May I?
Your client tendered those documents.
Let me look.
Sumedu,
36 services.
act আপনি দিয়েছেন exhibit 1 to 9.
Notes have.
with copy to Mr. Basu.
Give a copy.
I shall start.
You can serve it after he concludes, no problem.
Sir, on 22nd, I have a case in Bangalore.
Maybe you take an adjournment.
It is evidence stage, sir. It is in,
You take an adjournment. You say that you are requiring that you withdraw the petition. Take adjournment on this. You have sufficient time.
even to take adjournment, I have to be present in that court, sir.
Take adjournment. 22nd, you have a problem.
Yes, sir.
Then we'll make it next week. Next week now, then we can go.
16. 16 तारीख देखो.
हाँ, 16 तारीख ना? 17th to 17th.
So that is too short time to prepare for this.
What did you get time?
Also,
What
the
is your 17th or 22nd? You tell us.
14 there's 14 there's a
17th or
case in the
24th?
Supreme Court. 14 there's a case in the Supreme Court.
Keep it on 24th. We said 24th of August. Your case is on 22nd, you said.
I have to come from Bangalore. I won't get any train also.
No, sorry. You make arrangement. You have sufficient time. 22nd is your case. You book your ticket now.
It is not, the train does not reach here by 24th.
We don't know, Mr. Basu. Please make arrangement.
ट्रेन पहुंचो ही ना 22 तारीख ट्रेन होती 24 तारीख ट्रेन पहुंचा आश्चर्य
আমাকে ওই এক্সিবিট 1 to 6 টা দিন না একবার এক্সিবিট 1 to 6 টা
अच्छा